Thank you for joining today's Technology Transactions webinar. Our program today will focus on software and data audits, tips to avoid the traps. My name is Brad Peterson, and I'm delighted to introduce today's program. I'm a partner in Mayer Brown's Chicago office and lead our firm's Technology Transactions practice. Our Technology Transactions practice at Mayer Brown includes 50 lawyers worldwide who've done over $200 billion of data, digital, outsourcing, and software transactions. When there are disputes to resolve under those transactions or technical intellectual property issues, our Technology Transactions practice turns to our intellectual property practice. So today I'm delighted to have with me our IP practice, which comprises more than 100 intellectual property professionals around the world protecting, preserving, and enforcing intellectual property rights, including for some of the world's most innovative and inventive companies. I will cover a few administrative matters and then we'll get started. First, at the bottom of your screen, you will notice that there are multiple application widgets that you can use. All of the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. You can expand your slide area or maximize it to full screen by clicking on the arrows in the top right corner. Today's program is being streamed through your computer, so there is no dial-in number. For best audio quality, please make sure your computer speakers or your headset are turned on and the volume is up so you can hear the presenters. For the best viewing experience, we recommend using a wired internet connection, preferably with Chrome or Firefox browsers, and closing any programs or browser sessions running in the background that could cause issues. Some networks cause slides to advance more slowly than others, so logging off a VPN is recommended. If your slides are behind, try pushing F5 on your keyboard to refresh the page. Again, F5 might refresh the page and keep you up to date. You can also find additional answers to common technical issues on the Help widget at the bottom of your screen. During today's presentation, you will be provided with an alphanumeric code. If you are applying for CLE credit, you will need to record this code on the virtual sign-in sheet that you received by email with the connection details. You can also find a copy of the virtual sign-in sheet in the resource list widget entitled CLE Affirmation Form. And directions for returning the CLA affirmation form are on that CLA affirmation form. We will read the code in the middle of the presentation and then again at the end of the presentation. Please note, we've also made the event evaluation form and presentation deck available in the resource list widget for your convenience. This webinar is being recorded, as we normally do with these programs, and in a day or two, we will be sending you an email with a link, which you can use to listen to the webinar again or share it with colleagues. The recording will also be posted to our website. We do plan to allow time at the end of the program for questions. If you have a question, please submit it electronically using the Q&A widget. If we don't get to your question during this webinar, we will make every effort to follow up with you after this webinar. So with that, I'm pleased to introduce my colleagues and today's speakers, Rich and Valerie.
Thank you, Brad. I'll start. My name is Rich Assmus. I'm a partner in the intellectual property group in the Chicago office. I'm just passing my 20th anniversary at the firm. I wanted to give you a little idea why I'm interested in the topic of software and data audits. I started my career as a litigator, actually doing mainly patent litigation. And pretty early on, I developed a keen interest in transactional work and have maintained a balanced practice that involves both litigation and transactional work. And audits, to me, are the perfect marriage of those two disciplines. They often involve negotiation, negotiating the scope of the audit, negotiating a settlement of the audit, potentially renegotiating the underlying contract. But they also involve a fair amount of litigation planning. I like to think of audits as hoping for the best and planning for the worst, where the worst is litigation, and that lends itself well to a lawyer that does both. And now I'd like to ask Valerie to briefly introduce herself.
Thank you, Rich. So my name is Valerie Vanryckeghem. I am a Belgian qualified lawyer, currently practicing in the London office. And I've started my practice also both in litigation and in technology transactional work. I developed a little bit of a practice within a practice, becoming specialized in these type of files, software audits, and I've advised several clients in this regard. I think, Rich, you can now continue with the agenda of today.
Thanks. So Valerie and I are going to switch off during the course of the hour, but I wanted to start off by describing our agenda for the day. We're going to say what software and data audits are and what they entail. And we're going to discuss why we think audits are such a hot topic, including technological changes in the way that makes audits more valuable for vendors. I should also add that our belief in it being a hot topic was really confirmed by the level of interest that we've seen in this particular webinar. We're also going to talk about the common issues we've seen in audits. Collectively, we've been involved in scores of audits by vendors large and small, and I think it's akin to seeing the same genre of movie again and again. You see the same situations, the same themes, the same conflicts. I'm not going to say it's a horror movie, but it is not a rom-com either. So what are some of those common issues that we're going to talk about? It's surprisingly difficult even for sophisticated audit victims to identify the governing agreement that governs their use of the software or data. So we'll talk a little bit about the problems we've seen there. Virtualization is another very common topic, and that's when companies, licensees are attempting to use virtualization to reduce their license costs. That's obviously a hot button issue for vendors that want to maximize the value that they're getting from their licensees' use of the software. We'll talk about other usage metrics that lead to audits, as well as the issue of indirect use of software and derived data. So all of those are topics that take place during the audit. Then we'll turn to what happens after the audit is over, how audits are often settled, what are the parameters of that settlement, and we'll talk then about audit clause negotiations, or really renegotiations, which is one of the ways you might consider settling an audit based on the learnings of that audit. In other words, what was problematic about that audit clause that made the process more costly or more difficult that you might get to the vendor to agree to some changes to make the process more efficient in the unfortunate event it needs to happen again. So, starting with what are software and data audits. We see two types of those audits. The first is a court-ordered audit, where in connection with a lawsuit as an element of equitable relief, a vendor might get the right to conduct an audit ordered by the court. We're going to talk today more about the second type of audit, which is a contractual audit, an audit that the vendor has the right to conduct by virtue of an audit clause in a governing agreement between that vendor and its software data licensee. And those audits can check various things about the way the licensee is using the software or the data. Some of those are very objective and some of those are less objective. The first three that we have listed there are all somewhat objective. What CPUs is the software being used on? What named users have access to the software or the data, what locations is the software or the data being used, all very concrete things. What often is more problematic is the less objective factors. So, for example, a software or data license may prescribe certain uses that the software or the data may be used for. So, for example, you may be able to use the software for one type of customer, but not a different type of customer, for one purpose or not another purpose. You might be able to use data in some contexts, but not others. You may be able to give data to certain users, but not others. And then another tricky issue is the use of derived data and indirect use of software that I mentioned earlier. What, for example, are the parameters of use of data where the data that is under license, is transformed in some way and given to other users, does that count as use of the data subject to the parameters of the license? And I'm going to turn it over to Valerie now to talk about, actually not yet, one more. So how do these start? Often they're presented as an optimization project, and by that it's presented by a vendor as a way for a licensee to save money. And it is sent often not to the legal department, but to a sales associate, someone who has a relationship with that vendor, maybe an operational relationship or a sales relationship. And I think one question to ask yourself, if your client or your company received an audit request, would you in the legal department know about it, and when would you know about it? And if you're not confident that you would know about that project, that audit, right away, that might be a problem, because a lot of communications can go on before the legal department is involved that can be problematic. These audits are often tied to quarter end, either because that's an actual sales target for the vendor or a way for everyone to drive an audit to a conclusion using a deadline. The audit methods can vary quite widely. Sometimes they're as simple as a written Q&A and maybe a phone interview. Sometimes they involve running scripts remotely, some sort of audit tool that you either have already installed or will require you to make some new installation on your computer systems. Sometimes the audits are on-site, and sometimes it's all of the above. They might start with the written Q&A, start with phone interviews, later involve some sort of remote tools, and also involve on-site visits, and they can be multiple rounds of all that. And because of the complexity, they vary widely in timeline. Some take months, some take years. And now I'll ask Valerie to talk about why audits occur.
Thank you, Rich. Yeah, that's the next question indeed. And it is very interesting, certainly, for companies to understand why they are selected for such an audit. And part of it certainly is due to bad luck. A vendor might just select certain companies at random. But apart from that, there are also some other mechanics that come to play. And on the vendor side, it's important to understand it's definitely a business. Some software vendors really see it as a steady stream of revenue, and apart from that, also if the vendor has experienced that certain clients have compliance issues with certain contracts or usage metrics, they will use that to their advantage and perform audits in that respect. I have a case that I worked on, and it was a client that unlocked, or at least the IT department of a client that unlocked via a switch a second part of a software, but in reality they hadn't used it. But the mere fact that they were able to unlock a second part of the software was not a coincidence. That way they really entice the possibility to go beyond what is really allowed under the license. And then another part of the reasons why audits occur is that the software vendor might suspect certain bad behavior with certain clients. If a client has had compliance issues in the past, they will make use of this knowledge and, of course, go for a second round of audits with the same company. And then the final reason, it's a bit of an urban legend, but it has been said that independent auditors which discover irregularities during their audit might tip off the right people with the software vendors, and this might also lead to software audits. Why is it such a hot topic? Certainly, tech developments have caused the number of audits to rise, because technology advancements have led to more difficult interpretations of the the contractual frameworks that underlie there. For example, there's a recent movement for companies to go towards SaaS models, software as a service, and then that has led vendors to monetize for the final time on older investment, on older models of software use. Apart from that, nowadays there are also big data processing tools which allow auditors to have a full view very quickly on how certain software programs have been used in the past, whereas before perhaps they would first have to go for the Q&A, as Rich you pointed out, and then in a later stage try to perform the audit on site in order to get this full view. And even then, it would sometimes be difficult. But nowadays, with technology advancements, this is much easier for the software vendor. Also, the way companies use data has evolved much quicker than the underlying contracts describing such data usage, right? And considering that companies nowadays derive a lot of value from that data, also this has led software vendors to perform more audits and to focus on data usage rights during such audits. Apart from that, again, there are also some wider changes that might impact software and data use, such as M&A activities, which could lead to a need for consolidating and splitting software rights, and also outsourcing and cloud projects, which are often led by intentions to reduce license costs, but they can lead to questions in relation to the clarity of use and misuse. Well, it's no surprise that this all can lead to a somewhat strained relationship between the software vendor and the licensee, because of course they have different interests in mind. The software vendor is looking for added revenue stream, for an additional revenue stream, whereas the client is mostly concerned by its business continuity. And to be fair also, there's probably also a little bit, if there's a lack of a solid software or data asset management processes, this can really pose a risk for the client, because once the software vendor knows that a certain client has a poor software or data asset management, the vendor might decide to attack on a regular basis because they know it is not managed very well. And from a client's perspective, of course, it can be immensely disruptive financially, because the initial claims are potentially very high. Usually the software is bought at approximately 70–80% discount, but the contract is not very clear on which price can be asked in the event of non-compliance, or when additional licenses need to be bought. Are they supposed to be bought at the same discount, or is nothing? Does the contract not deal with this? Then this could also be a risk financially. And then from a business continuity perspective, they are of course concerned that they might lose their right to continue using the software or certain functionalities. Let's go to the next slide. Yes, some interesting claims making it to court. Not all make it to court, but there have been some that managed to get to court. SAP Diageo case is the case that opened the indirect use box. We'll talk a bit more about that later. The highest profile case was, of course, against AB InBev, which was settled for a substantial amount. And then the 118 data resource case dealt with an audit clause, which was drafted in a very broad manner. And 118 data resource applied for summary judgment to enforce this audit clause, but the court ruled that the audit right was not sufficiently clear to grant the order. So this is also a very interesting case in relation to how a audit clause should be drafted in order to be enforceable. Which I think it's time I hand it over back to you.
Great. Thank you, Valerie. So we've talked about what audits are, why they're such a hot topic, and now we want to turn to how to deal with those audits. We're going to talk about that both generally, talk about it, steps to take internally, and talk about how to deal with it vis-a-vis the vendor. And I'm going to start off with some general observations on how to deal with it. And the first is to manage it as a project, which is something that your IT departments are often very good at. They're very good at managing projects, installation projects, upgrade projects, and they should think of it, and the legal department should think of it as a project management exercise. It's something that's going to go on over a course of many months and have multiple overlapping independent work streams. We recommend appointing a single point of contact to discuss issues with the vendor and to establish clear lines of communication. And that's in contrast to it, everybody talks to the other side situation where you have people at all levels of the organization talking to their contacts with respect to the audit. Now, we understand that, for example, a vendor that's running your ERP system, of course there's going to need to be regular, ordinary course of business contact with that vendor on a number of issues. But with respect to the audit itself, we think it's important to establish communications protocols. We mentioned before the importance of getting early notice of an audit, and that's in part to make sure that the legal function is involved in managing the course of that audit, and in particular in managing it in a way that preserves to the maximum extent possible any privilege that might exist with respect to the communications between the lawyers and the IT department over that investigation. As I mentioned before, we like to hope for the best and plan for the worst, and planning for the worst here means planning for the potential that this audit will turn into litigation. Now that is a rare occurrence, but if it does turn to litigation and the communication lines were not managed properly, there's no telling what type of admissions may have been made in connection with non-privileged communications, either among the IT group or between the IT group and the vendor. So we believe it's important to take care to document the process in a thoughtful manner, but be careful about what's committed to writing, and to make sure to train the audit team on those communications protocols, because they are not typical communication protocols. They're very atypical, in some ways unnatural to the employees. We also suggest to avoid finger pointing. Certainly when an audit comes in, someone is going to be looking for blame. When the claim comes in and the dollar amount is huge, it's not surprising to see a dollar amount that would double the IT budget for the year. You can imagine that the discussions that need to go on between the chief IT officer and the CFO or the CEO about, wait a minute, how could my budget have had this problem? How could we not have known about this? It's very natural to engage in finger pointing, and our recommendation is there is, yes, ultimately there needs to be some sort of root cause analysis to determine how to avoid this in the future, whether processes need to be changed. We suggest saving that for after settlement, doing what we call a post-mortem on the audit process to figure out how to make it more smooth, how to avoid it altogether, but not to do that while the audit is ongoing. So, what to do internally? Certainly collecting all the relevant documents is important. The contracts, the purchase orders, the invoices, all of those things can hide terms that are relevant to the audit and the rights. Earlier audit reports, if there was one, earlier settlements, pricing lists, and potentially correspondence with the vendor. We don't think this needs to turn into a full litigation document collection, but it is important to understand what's out there. And oftentimes we've seen that the interpretation of the contract is one that the business thought it understood based on conversations with the vendor. To the extent that there are admissions on either side, it's important to look at that correspondence to understand what positions each side has taken with respect to, for example, the interpretation of a particular contract clause. And turning to those contract clauses, you do want to get a handle on the key clauses in the governing agreement. The audit clause, for sure, to understand the scope of what the vendor has the right to do. The license grant, of course, so that you understand what rights you have, what rights you don't. What are the obligations in the event of any under-licensure? And what is the liability regime? Is the entire matter subject to some sort of cap on damages? Is it uncapped? Are there other theories that the vendor could apply to get uncapped damages? So, for example, could the vendor argue that your use beyond the scope of your license was an extra contractual claim, for example, a claim for copyright infringement? You want to have an understanding of all of these key clauses really as the audit is beginning, because the way those clauses read might inform the way you permit the audit to be conducted, inform the way that you respond to the audit. You'll want to assess your tools for tracking compliance. Do you have a software asset management tool in place that you can use? Are there other logs that you'll need to consult to address the vendor's claims? And we'll note that particularly with respect to data usage, the infrastructure may not just exist at all in your environment to track that type of use. That's part of the reason that data audits, we think, are a growing area of concern, because it's not something that the IT departments have quite as much experience tracking compared to software usage. And thinking about planning for the worst, you really need to think about document preservation. In other words, are there logs that are created that might bear on some of the audit issues? If they're, for example, rolled off after 90 days, you'll want to make sure that you have those logs. Or if there's other document preservation issues that you'd want to address before you get to the point where somebody's asking you in litigation why those documents weren't preserved given their probative value in the audit. So we do think it's a good idea to assess the legal and financial risks up front to get a sense of how the audit is going to proceed. Is it worth the candle, so to speak? If the risks are low and the dollar amounts are low, you might take a different approach than if the risks are high and the dollar amounts are higher. You want to assess your options for and maybe even perform some sort of cleanup. We've seen instances where the claim is that a whole group of users had access to software. Well, whether or not that actually led to any use, if you have the ability to cut off that access, go ahead and do it. We don't see any reason not to take those sort of prophylactic measures right away. You want to assess your further product dependency. Are there products that you really need? Are there ones that you could sunset? Those might impact the way you allow the audit to be conducted and the risk you assign to it. You also want to look with other points of leverage with the vendor. Oftentimes it's only one software program within a suite of programs being audited, and you have projected growing use with the vendor. That might be a source of leverage. You might have new business lines that are opening up. You might have strong consulting relationships completely outside the software arena. That may be a point of leverage. And you want to plot a strategy for conducting the audit. Again, we talked about single points of contact. We've observed a little bit of a good cop, bad cop type approach from certain vendors where they have one person who's indicating that there's ways to settle this and others threatening litigation. We think that as a licensee, you're probably better off when there's a single track, when you know that the person you're dealing with has the authority to settle the matter, the authority to make concessions on behalf of the vendor. And we believe that the same should be true on your side. You want to have someone who's authorized to make decisions on the company's behalf, understanding that that will often need to be involve some sort of committee or other governance process on the licensee side. And with that, I will turn it over to Valerie to talk about dealing with the vendor during the course of an audit.
Thank you, Rich. Yeah, indeed. So you are in the midst of the audit process. How do you act towards the vendor? And the first thing that we have always recommended to our clients is to buy time. First of all, you will need this time to go through the steps, as mentioned just now by Rich, to go through the contractual framework and to assess it, to assess the current and past use, the IT landscape. So you will need that time. And it is typically the vendor that is rushed for time, and it is the vendor that wants to make a quick deal. And exactly as you said, Rich, they will play out the good cop, bad cop way by having, for example, the legal department saying you were non-compliant, and then also having somebody from the commercial department suddenly contacting the client saying, look, we appreciate the relationship, but we can fix it with some forward buys and perhaps a new program, and we will give you a good discount and so forth, and that would be the good cop then, of course. But so you should not be rushed. You should buy some time, and before you start the process, you should definitely also ask for an NDA and, of course, the coverage for risk related to the use of an audit tool, if there is any that they intend to use. If there are some parties that have been involved, for example, as an integrator or a reseller of the software, and they might have some responsibility for the use of the software by the client, we recommend involving them from the get-go. Also, we would ask the vendor to provide transparency on the tools that they will be using, and for the client to reserve all rights when cooperating during an audit. The second step then, of course, is to challenge the vendor. While it is absolutely necessary from the client side to try to establish the contractual framework for itself, we would also recommend asking the vendor to identify what the relevant contractual framework is, because we've seen more often than not that they're actually not capable of identifying the relevant contractual documents. And we shouldn't forget that if they claim we are not compliant with the license terms, they do have the burden of proof. So we should challenge every assumption. And then, of course, it is possible, and it has happened before, that software vendors threaten to discontinue a software support or to file a suit. But we would recommend the client to evaluate the credibility of these threats, for example, by looking into the litigation, into history, background of the contacts with the software vendor, user group resources, and so forth. The contractual framework with the biggest software vendors, certainly, such as SAP, Oracle, and so forth, they consist of multiple layers of contracts and incorporated terms. You might have contracts, order forms, multiple TNCs which have been communicated over the years, different price lists, policies. And so there are very complex contractual frameworks, and sometimes, well, actually quite often, some of the terms have never been signed or explicitly agreed to by the client. And this leads to the question of enforceability. And of course, the exact rules on enforceability will differ depending on the jurisdiction and the applicable law. But it is worth challenging the contractual framework and the different terms to the extent that the vendor relies on them. So let's go to the next slide. So virtualization, the most well-known example of it is VMware. And virtualization is actually a technology that makes it possible for a company to partition a single physical server into multiple virtual machines. And that is also, again, to reduce a license cost that some clients have invested in this technology. For example, a software could be installed on a physical server, but then also could be used by the different virtual machines, actually leading to the requirement to obtain additional licenses if you have a CPU-based license metric. And the funny thing here is that VMware had published guidelines a couple of years ago saying, look, our software is safe to use with Oracle. This has resulted in Oracle publishing its partitioning policy, in which it made a difference between the soft partitioning and the hard partitioning. And basically what Oracle said, well, look, we don't recognize a soft partitioning, which is the virtualization technique that VMware relies on. So they only recognize hard partitioning. And this is of particular importance because we had a case actually at that point in time, and it was against Oracle. And also there was a CPU-based metric. And the client had invested in VMware because they relied on the guidelines of VMware saying that it's safe to be used with Oracle, but unfortunately Oracle acted upon that, saying that its partitioning policy explicitly mentioned that a processor must include all processors upon which Oracle programs potentially could be installed or could run. And in this particular case, we were able, and this goes back to the first common issue that we encounter, we were able to say that the partitioning policy of Oracle was simply not enforceable to our clients because it was never communicated even, let alone accepted by our clients. And apart from that, in that particular case, we were also able to argue that Oracle had specific duties as a professional IT services provider because our client had communicated with Oracle about its intentions to start using VMware, and at no point did Oracle mention, well, look, you will need to purchase additional licenses because we do not recognize this type of soft partition. So we were able to make a strong case on the basis of these two arguments. And then let's move on to the indirect use issue. This is also a result of technology advancements because traditionally the way software was used was a company would install the software and it would have a workforce and let's say 10 people were allowed to use this specific software in a specific way. And whereas now, due to technology advancements and clients or companies investing in third-party SaaS solutions or internal and external application bots or other products, the software would actually be used by applications, and the question has risen whether or not the third-party product is the user of the software or the physical person all the way in the end using the third-party application that uses the software indirectly is then actually the user of the software. And it will be no surprise that the vendors have taken the opinion that it is always the end user that needs to be licensed, the physical end user that needs to be licensed, if that is, of course, your license metric. But there have been quite a lot of discussions on this. And the most notable recent case is the SAP Diageo case, where there has been indirect use, or at least the court decided in that specific case that there had been indirect use. But again, license terms matter, because at the point when the judgment on the SAP Diageo case came out, I was dealing in Belgium with another audit, and that also was related to indirect use. But in that specific case, the contractual terms were a little bit different. And one provision there said that in order to speak of use, that is for which you should be licensed, there should be access of data and functions of the software. So the mere access of data would not suffice to speak of indirect use. And in this specific case, that was actually quite important, because there was a lot of mere extraction of data. So this is just to give a little example as to how license terms matter, and it really is valuable to study the contractual framework closely during an audit. Rich, I think I'll turn it over back to you on this one.
Thanks. Thank you. So this last of our common issues is derived data, and it shares a lot of commonalities with the indirect use issue that Valerie talked about. And I think a theme you will see developing here is that one of the friction points in audits is the way that technology can outpace the language of the contracts. In other words, you may have a contract vintage 2005, even vintage 2010 for that matter, that in 2019 doesn't match up well with the way these tools are being used, with the way this data is being used. And you see it as well in the derived data issue, which comes up in data licenses. One other observation on data licenses, I don't quite know why this is true, and that is that the data vendors seem to be more successful in getting companies to sign their form paper. I'm not sure why that is. Maybe there's more knowledge of the way you can get better bargains by negotiating with a software vendor, but we've seen a lot of form paper in the data world, which means that the data vendors are getting stronger audit clauses and stronger data usage rights. So what do we mean by derived data? Of course, just like the way a software vendor wants to manage the way a licensee uses its software, which is fair and appropriate, a data vendor wants to manage how their data is used, which typically means access. So step one in the audit will be who has access to that data. If it's a rights-managed environment, you can check who the users are that have access to that data. In that sense, it's very similar to an audit. Where there's a departure in similarity is in step two, which is who has access to the work product created from that data. And an example of that would be financial market data from which other reports are generated. So does that count as access to the data? If, for example, there's a financial data that is given to a select group of users, what about the reports that are generated either by the system or by human beings in which that data is embedded? And many data vendors are trying to police the use of that derived data. And the plain language of those data agreements, which are often we've seen unnegotiated, purport to govern the use of any data from which the underlying license data can be gleaned. And as you can imagine, trying to track that down can be very difficult. You really need to look at the particular reports that are being generated, how the reports are being used. An example of this might be some pricing data that's used to create a report on value, where deriving the underlying pricing data is a simple matter of reversing the equation. We've seen that issue come up a lot. We think it's going to come up even more often in our data-driven economy. So that takes us to the end of the audit. Those are the issues we've seen. What happens when the audit findings are disclosed to all the parties, and you need to sit down at the table and figure out how to settle this matter. One thing we've seen that Valerie mentioned is that we do see big reductions in the headline demand that the vendor makes. And we think there's a couple reasons for this. One is, as Valerie mentioned, oftentimes those rack rates for software are a bit of a mirage, sort of like the rack rates for healthcare costs, where no one really pays the rack rates, so that the discount is tremendously high. And that means that if a software vendor or a data vendor is pricing the under-licensed work at rack rates, you're going to see big numbers. We also think that it's probably smart psychology on the vendor's part. There's something called the framing effect. And what that is if you frame the issue as do you owe us this 9-figure settlement or not, it can often be psychologically considered a bit of a win to get a reduction, even if the original number was really not a realistic number. So we think there's part of that going on. In terms of the settlement, certainly you'd want a full release for any past events, hopefully known or unknown. You really want to buy peace with the vendor, sort of reset the relationship. Valerie talked before about the different frames of mind that are brought to the audit. Vendors rightly want to get compensated for the use of their software. That's their business model. There's nothing wrong with that. And they tend to view under-licensure as a form of cheating. Whereas from a licensee perspective, they tend to view that as sort of an honest mistake, a foot fault. And those two different frame of minds sort of butt heads in the audit process, and you see it in the settlements as well. Another thing we recommend is having a grace period for future audits. You don't want to settle audit and then immediately have the next one commence. Oftentimes we think vendors are willing to do that if the underlying settlement is fair in their minds. And we certainly would not want that settlement to make any admission of liability if your history of audits ever became an issue in litigation. Oftentimes the settlement may require some sort of clarification or adjustment in the licensing regime. For example, sometimes it may make sense to move from, say, a named user license to an enterprise license, or otherwise make the licensing regime easier for the licensee to manage. Oftentimes there's really no ill intent here or bad faith. It's as people their crystal balls are never perfect. I think Yogi Berra used to say, projections or predictions are hard, especially about the future. So it's not surprising that when you're writing a software contract 10 years on, things have changed. The licensing metrics you decided then might be very hard to manage. And so maybe it's an opportunity for both you and the vendor to have a system that's deemed more fair by both parties. There also may be specific terms that are subject to dispute that you would want to clarify in a settlement. And you might also consider renegotiating the audit clause if you've learned something through the audit that makes you realize that the audit could be more efficient for both parties. So what are the factors that contribute to the settlement? We've seen again and again the same factors be at issue. Certainly the strength of the audit findings and the technical basis for those allegations. The strength of the vendor's contractual claims. Sometimes the contract is very clear and the vendor has a strong claim for under licensure. Other times they may be stretching the bounds of that contract in a way that's deemed less strong. The evidence of overuse is certainly a factor, and a factor I don't list here, and that is sort of the equities of it. So, for example, if the licensee really didn't derive any value from the under licensure, so for example, if the usage metric was access to the software, but does not say anything about use, the vendor would certainly be right that merely providing access to that software is under the terms of the contract, an under licensure if you don't have enough of those users. But on the other hand, from an equitable perspective, what is the additional value that the licensee derived from that access if those users maybe didn't even know they had access to that software? And we think that those equitable considerations do play a big role in setting the parameters of the settlement. Certainly the other communications and admissions that might exist are a negotiating factor, as well as the strength and future of the relationship. Is this a software that's going end of life, where the vendor is trying to get the last monetization out of it, or is it something that you're expecting to upgrade and use on a number of new projects? Is it a relationship that's going to continue? Again, that's a real point of negotiating leverage if the vendor has a promising relationship with you. A couple different negotiating approaches we wanted to mention. One is simply standing on principle, and I think certainly that's often the first reaction on the licensee side if they've been accused of cheating but feel like they've been acting in good faith. The other approach is to treat it more like any other litigation type claim. You realize it's a cost of doing business. You're not saying you're wrong, but you realize it's not worth taking it. And there's a lot of points in between on that, and we've seen clients, as the audit process goes along, really vacillating between wanting to stand on principle and wanting to just get it behind them. We think ultimately the getting behind you mantra tends to prevail in the end, which is probably better for everyone. So talking a little bit more about renegotiating audit clauses. Couple points of contention we see: the audit process, deadlines for completion, what I call the foot-fault clause, which is that you can have some right to rectify the situation for mistakes that are made with no bad faith, as well as damages caps. I wanted to quickly point out how these audit clauses can be deceptively simple but deceptively bad. So this particular audit clause is about 3 or 4 sentences long, a very small part of what could be a much longer contract. And it's really a very simple audit clause in many ways, yet it is very licensor favorable. So don't be under the impression that a long audit clause is good for the vendor and a short audit clause is good for the licensee. Oftentimes, from the vendor's perspective, less is more. And so the problems we see with this clause are that it's a very short notice period. It's very wide in scope. It says the licensor may audit your use of the program. So you could drive a truck through that door. There's a duty to cooperate, a short payment deadline, and very importantly, it's unclear what rates apply. It says you agree to pay within 30 days of written notification any fees applicable to your use of the programs in excess of your license rights. Well, what are those applicable fees? Is it the discounted rate? Is it the rack rates? Is it the rack rates that were in effect at the time of your license, or is it the rack rates that are in effect now? Again, very simple audit clause, but in our view, really a disaster for the licensee. And as you'll see, there are also several hammers for the licensor in this clause. They have the right, for example, to end technical support, end the licenses, or even terminate the agreement. And this is a termination right that's hiding in an audit clause. It's not even in the termination section of the agreement. And with that, I'll turn it over to Valerie for a couple other considerations in renegotiating audit clauses.
Thank you, Rich. Yes, indeed. So you've given a good example of a licensor favorable clause, and on this slide we find a couple of considerations or options actually if you have the possibility to renegotiate the audit clause. And of course, I appreciate such thing will be difficult with the likes of Oracle or SAP. But sometimes you do have the option to renegotiate the audit clause, and what we would recommend is always to try to have a staged approach, which means first go for the Q&A. If the results turn out to be unacceptable or give rise to additional questions, then go for the on-site audit, but with a justification and only as a second stage. And then we would always recommend, if you can renegotiate, to include an obligation to conclude a confidentiality agreement directly with the auditor. And then also, once you have the audit results, what is a really good provision is that the parties need to discuss in good faith with a view to resolving any issues that, in a way that strikes a fair balance between the interests of the vendor and licensee. So this way, you're actually you're demanding from the parties that they find a balance between the interests of the vendor and the licensee, which means the interest of the vendor to have its intellectual property rights respected, but also for the licensee not to be punished for bona fide transgressions. And that brings me also to the final bullet point on this slide. So in one case, we were able to renegotiate the audit clause and to include a provision which read that the client was allowed to remedy bona fide transgressions of the license parameters which were not intended to circumvent license terms and conditions. So this goes very far, as you can see, because you will probably not be able to achieve that with Oracle or SAP, but if you have a strong relationship with the software vendor and you have quite a bit of leeway in the relationship between the software vendor and the client, you might be able to negotiate a clause like this. Oh. And then the final slide. This is useful in relation to the renegotiation of the audit clause, but also in relation to the settlement agreement. Is to include language in relation to additional purchases and the price at which this needs to happen. So if you can include a provision that says any additional purchases shall be at the same discount as the original license, that can be very useful in the event of an audit. The same goes for swaps between licenses. What we see very often is that the client purchases different types of licenses, but then at some point realizes, well, actually I should have bought a bit more of this type of licenses, but a bit less from the other type of licenses. And it is very useful if you have included a right to swap between licenses which you haven't started using yet. And the same mechanic can also work with under-licensing and over-licensed products. For example, if you're in the midst of an audit and you notice that some of your software products are under-licensed, whereas other or over-licensed, and by that I mean you actually are allowed to have, for example, 100 users, but you're only using 50, then it would be great during an audit that you have the right to compensate those 50 unused users by swapping them for the under-licensed product, and for example, the 20 users that you're not licensed for in relation to the other product. I think that leads us to the final slide that has questions on it.
And we would like to, we unfortunately have come to the end of our hour, but we will get back to the people who have provided questions. And if you have additional questions, please take the opportunity to reach out to any of us to discuss this webinar further. We'd like to take this opportunity to highlight 2 upcoming programs for those interested. Invitation links for both can be found on the resource list widget. On May 14, we invite our buy-side friends to attend our 13th annual Technology and Innovation Conference, which is titled Doing Business in a Connected World. This full-day conference will feature TED-style tech talks, in-depth presentations and panel discussions covering some of the hottest trends in data, digital services, outsourcing, and software. The conference will be held in Chicago and will also be available by webinar. We also invite you to participate in our next webinar, Software as a Service, What You Need to Know, taking place on June 13. And this wraps up our program. And on behalf of Mayor Brown and my colleagues, thank you today for your time. I hope you found this program useful. I certainly did. Some final housekeeping items for today's participants. A recording and link for this program will be distributed by email in the next day or two. And finally, to submit topic ideas or receive invitations to future programs, please do email us at techtransactions@mayorbrown.com. Thank you for participating. This concludes our webinar.